please.
And welcome back.
Welcome back. Yeah, welcome back.
2, 3, 4.
All right, everybody, welcome to the show tonight. The purpose. Oh, stop it! Stop doing the thing, Jesus. All right, the purpose of the show this evening is because there has been some great movement in the court of Georgia over the last few days, and so we're going to kind of go through that. I've seen some other people go through this, but this is the law student review of the attorney, Mr. Steele, in the Georgia case, and basically saying that, like, this is the attorney we should all aspire as law students, in my humble opinion, to be. So we're going to go through this real quick and talk about the legal issues that are at play, as well as my opinions of them. So here we go. We're going to watch a little bit first and then kind of go through it. So this is, okay, so for the people who don't know, so this is the YSL trial in Georgia right now, right? It's a RICO trial, which the Georgia RICO laws are very fishy, to say the least, right? And so basically there are 24 defendants that have been called right now, and there are 6 currently at trial there. So that means there are 18 left to be tried after this. And we have a man named Kenneth Copeland right now who is on the stand. And so there's a whole issue with an ex parte hearing where Mr. Kenneth Copeland, who is a witness, in fact, to the case, right, who did some great work. If you're ever called to be a witness and you don't want to be a snitch, he's great. They ask him stuff like, hey, what's your name? He's like, I don't know. How old are you? I'm grown. So he did a very good job being a non-cooperative witness, because he's not going to be a snitch, because he realizes if he gets back out on the street in Georgia, it's not going to go well for him. So that's very good. After that, so now we have attorney for Young Thug, Michael Steele, who is being called to the stand, and he says that he's not going to give any information about ex parte hearing. So ex parte hearing, for those who don't understand, an ex parte hearing is a hearing where one of the parties is not present. So in this case, there was a meeting that was held between the judge, between the witness, Kenneth Copeland, Lil Woody, his rap name, right? All the prosecutor's office and some bailiffs, right? None of the 6 defendants and none of their attorneys got to be present for that hearing. And so we had Michael Steele, prior to this video we're going to show, go up and say, hey, Your Honor, this is not okay. Because my client has a 6th Amendment right, which has been incorporated in the Constitution of the United States and the Constitution of Georgia for coherency, right, to a speedy trial and proper representation. You had a private secret squirrel meeting with the client, with the witness, not the client, I'm sorry, the witness, where you got a bunch of stuff out of him, and you didn't tell us that happened. Not only did you not tell us that happened, you did not allow us to be there. My client, Young Thug, has a constitutional right to be there for that. And if not him in person, and me as the defendant had the right to do that. And so what happened is the judge lost his damn mind and held Mr. Steele in contempt. Mr. Steele, bless you, sir, did the whole, took the jacket off, took the tie off, was going to get perp walked to jail. He's like, I'm going to do it anyways. I don't care. So now we have, what we're going to watch right now is Ashley Merchant, who is now, okay, so let me put it this way. In Georgia, and I hope in other states too, they have this, like, the super friends. The super friends who are out there, and they're like, rapid response team. If there's a criminal defense lawyer who needs somebody to help them, if a judge goes off the rails and does something crazy, boom, they're coming in, and they're going to represent him. And so Ashley Merchant, as well as Mullet Man, I don't know his name, so I'm going to call him Mullet Man. If you look at the screen right now, you'll see Ashley Merchant in the pink, Mr. Steele next to her with the gray hair, and Mullet Man to the right of him. God bless Mullet Man. He's also very smart, very intelligent attorney, making arguments for Mr. Steele's behalf. And so that's what we're at right now. So we're going to listen to the arguments they've made, because the judge held Steele in contempt for daring to speak out that his client was deprived of the constitutional rights that he's entitled to. All right, so we'll listen to a bit of this real quick, and we'll go through it. with some commentary from a 3L law student. We'll go.
Hold you in summary criminal contempt.
The judge in Young Thug's RICO trial orders the rapper's attorney to jail for contempt.
How did you get that information supposedly from my chambers? Did somebody tell you? I'm not. You should have told me. You got 5 minutes.
This happened.
All right, so let me pause right there. So we understand what's happening, right? What's happening is that there was an ex parte hearing. An ex parte meaning without a party, right? So the party in this case being the defendant, the defense. The defense were not allowed to go there and to participate in the hearing with Kenneth Copeland, the witness, and with the state and the judge. And apparently during this hearing, as Mr. Steele will represent, told the judge that he was threatened. They're like, hey, bro, if you don't testify the way we want you to testify, we're going to lock you up for 2 years, 3 years, 6 years, who knows? We'll lock you up until we try every single defendant we have here on file. The 6 that are before us right now, and the next 6, and the next 6, and the next 6. And you'll be in jail until they're all done, which sounds a lot like witness intimidation, which is a lot like threatening a witness, right? And so Mr. Steele here wasn't having it. And so now he's trying to bring this to the judge's attention, and the judge is going to throw him in jail for that, right? Which is very problematic. So let's go forward a bit more.
After lawyer Brian Steele refused to tell the judge how he found out about a meeting between the judge, the prosecutor,
right. So
and the state's...
Okay, right. So the judge is like, who the hell did you hear it from? Who told you? And he's like, I'm not telling you. I have a client work product confidentiality, right? Since even if it's not my client who told me that, since I learned of this information in my client's defense, right, which is in defense of his client, then you can't make me do stuff. You can't make me tell you who told you. And the judge is like, oh, you're going to tell me who told you? He's like, I'll put you in timeout for 5 minutes and come back. And after that, I'm going to make you whatever. Here we go from there.
Witness. Steele's lawyer is here with what's next for him and Young Thug's trial. I'm Anjanette Levy, and this is Crime Fix. It was given immunity by the prosecution.
Oh my God, Levy,
he spent the weekend in jail.
How old are you?
Here we go.
By the prosecution.
So here we go. Real quick on this point. So this is Mr. Kenneth Copeland. This is Lil Woody, who was compelled to testify because the state gave him an immunity agreement, so his pleading the fifth wouldn't waive. And watch this. So if you don't want to be a snitch, if you want to be out there in the streets and you want to not be a snitch, this is a case par excellence of how to do that. Watch how this guy answers these questions. He's completely not helping the prosecution. He's out there on a limb and he's doing what he can. And the whole issue with this is after this, then the freaking court threatens him with jail time. And we'll get into that. But right now, watch how he answers this. This is golden.
He spent the weekend in jail after refusing to testify on Friday. Copeland took the stand on Monday and let it be known that he wasn't going to do it.
And Mr. Copeland, good afternoon.
Here we go.
Do you want to be here?
Ma'am,
Do you want to be here?
I'm here.
Okay. Are you going to let me ask you some questions?
Okay.
He's going to answer the
How old
question.
are you?
He's
Grown.
grown.
Okay, what does grown mean?
I'm an adult.
Okay. And when you say you're an adult, what number in years are you?
Look around.
I plead the fifth.
He pleads the fifth. He pleads the fifth to how old he is. So for those who don't know, pleading the fifth is that you refuse to say something that will possibly have criminal consequences upon you, right? So when he pleads the fifth to how old he is, it's obviously a thing. He's not saying anything to help his prosecution out. This prosecution, in my humble opinion, is crooked as hell. But that's where it's at, right? And so he's already being uncooperative. So the thing is that, so after this whole thing happened, right, then the judge took him back to chambers, to the judge's little chambers. Judge wearing the black robe with the prosecution, all the DAs there, and no defense attorneys, and was like, hey, bro, you better plead or else we're going to do X, Y, and Z. We'll throw you in jail for 2 years, 3 years, 5 years, 10 years, and was threatening him essentially with what they're going to do to him if he doesn't testify. And so at that point in time, under Georgia law, the defense had a right to be there, and they weren't there. So Mr. Steele then says, hey, this is a problem. We're going to speak up for it. So we'll see where it goes from here.
So after that, Brian Steele let the court know that he found out that Judge Earl Glanville, prosecutors, and Copeland with his lawyer met in chambers without members of the defense teams. And
White talks.
Belief that when we arrived at 8:30, 9 o'clock today, we did not come into your courtroom until almost 11:30. And what I found out.
Right. So what's going on, right, is like, so they all show up for court at 8:30 a.m., right, to be there on time. And Mr. Judge and Mr. Copeland and all the prosecutors had a secret squirrel meeting in the judge's chambers trying to strong arm Mr. Copeland to lie, to testify, to lie about other stuff, and he wasn't having it. And then Mr. Steele here just found out about it. So he pissed, and he should be pissed.
Just recently, this is not waived, is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel.
Look at them looking at each other. When he said district attorney, see the girl in the white there? That's Attorney Love. And attorney in the plaid there, Attorney Less Love. I don't know what her name is. Looking at you like, oh shit, we did that. Right. Sus as hell. It's sus.
Met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment.
So can I interrupt you just a second? I'm kind of disturbed because that's ex parte.
Yeah.
All that was an ex parte conversation. How did you find out about any of that?
Now, this seems really unusual that a judge would be meeting in chambers with a state's witness and the prosecutor without a member of the defense team there. But Judge Glanville was furious that Steele found out about the.
I'd be furious too. Okay. Point being. All right. Going back, right? What is wrong? Okay. My mouse is not. Okay. Bye, mouse. We're just going to use the whole scroll. Oh, my Lord. All right, cool. We got it. Okay, cool. We got it. We can figure it out. All right, cool. The whole point now, right, is that at that point in time, right, is that when the judge found out that he had been found out, right, the judge has been found out that all of a sudden somebody from that hearing had told the lawyers this bullshit went on. There was an improper hearing where there was the witness. So let me break it down. There's a witness who was on the stand who had been sworn in and was testifying. And he was still sworn in. And they took the judge to a separate meeting with the witness, the district attorneys, a lot of them, and a bailiff, and no defense attorneys. And they tried to coerce him to change his testimony in court. That's a problem. And so Attorney Steele here is standing up and saying, Your Honor, this is not right. My client, Young Thug, has been deprived of his rights because he has the constitutional right under the Georgia Constitution, under the United States Constitution, to be present for any significant portion of his defense. Do you think that a witness who maybe was witness to a murder, as he testified, right, and is changing his testimony to help the state out, that's not an important part of Young Thug's defense? You damn right it is. You damn right it better be treated that way. And so here we are with this the case as it is. So we're going to listen to this woman a bit more, and we'll go back to the trial. Hopefully,
meeting in chambers.
Here. Oh, here we go.
Upon this information.
Go. Go.
Who told you?
What I want to know is why wasn't I there?
The judge asked him,
Sir, I'm going to hold you in contempt if you don't tell me. Tell me who this information was coming from.
I don't want to be held in contempt. Well, I'm not answering that question. That's attorney-client privilege information. I am not
attorney-client privilege. Unless you were in my chambers, that's the only way you can figure out.
I
tell you what, I'm going to give you 5 minutes. If you don't tell me,
you don't have to.
If you don't tell me who it is, I'm going to put you in.
So here's how we go, right? So 3 things here. The first thing he's saying, I have knowledge of this. Don't matter how I found out, I found out. I found out that you violated my client's constitutional right to a fair trial into a zealous defense from me. The judge is like, well, shut the hell up. How'd you find out? Who told you? Who's the snitch? Who's the leak? He's like, I can't tell you that because guess what? We have a thing called attorney-client work product, right? Which means it doesn't matter where it came from. As long as I have contacted someone and that contact helps with my client's defense, right? I can't disclose that to you because it would hurt my client's defense. The judge is like, oh, no, you better tell me right now. No, tell me right now. No, you. Tell me right now how it is. And then the judge says, finally, he's like, I'll give you 5 minutes. Like he's a small child. Like, sit in the corner for 5 minutes. I'm going to come back. If you don't have an answer, you're in big trouble, buddy. And that's how this goes forward. It's crazy. This judge is out of line, in my humble opinion.
I'm going to put you in contempt.
Yeah, put him in contempt.
That is not attorney-client privilege.
It is.
Attorney work product privilege.
I am not.
How did you get that information supposedly
it doesn't
from my
matter how
chambers?
we got it.
Did somebody tell you?
I'm not. You should have told me.
Exactly. Steele says, you should have told me. The point isn't where he got the information. The point is under the Georgia rules of judicial conduct, under the Georgia rules for attorney-client representation, right? If this happens, it is incumbent, it is required of the judge to tell the attorney this information, and he didn't. So Mr. Steele is 300% right in saying, it doesn't matter where I got it. You should have told me about it. I shouldn't have had to find out about it from some other source. You are required by law to tell me if you're having these secret squirrel hearings. You haven't? And that's a problem. And here we go.
You got 5 minutes.
Linville actually ordered that Steele.
I don't care what you say. I'm sure you're a very lovely person, but that's not the point.
Not asked you sum and substance of what you said. I asked you how you got it.
I can't do that.
Yes, you can, because I have an idea how you got it.
Oh, you have an idea.
I have an idea how you got it. But
so the judge is saying that he has an idea. The judge knows. The judge is the all great and powerful Oz who knows how he got it. And so since he thinks he knows how he got it, he's going to try to tell him what the problem is. The whole issue with this is that as an attorney, if you come into information, you are not required to disclose that to a judge, to a fellow attorney, to God himself, if the preservation of that knowledge protects your client. And the judge is sitting here telling him, oh, I'm going to put you in the corner for 5 minutes if you don't tell me exactly where the hell you got this. Well, Your Honor, that's not how that shit works. And Attorney Steele, fucking good on you, man. Way to hold the line. Here we go.
But that's improper, sir.
Your idea may be wrong, and you're asking me to.
You might be
listen,
wrong.
I told you
might
the
be
first
fucked up, Judge.
And I'm not
Sir,
going to breach that confidence.
I don't want to hold you in contempt, but this is that
He
serious.
wants to.
Judge,
He says
You cannot eavesdrop and get.
Boom. Okay, so the judge says right there, and this is going to be a continuing thing going forward. The judge says, attorney, you cannot eavesdrop and get information. It's not an exact accusation, but it's pretty damn close, saying like, oh, I think how you got that accusation is you eavesdropped. You had a communications device, you had a fucking droid, you had something or someone in my fucking chambers listening in on what was going on. That's what the judge is accusing of us right there. And that's massively problematic, to say the least.
Information that was not meant for you to hear at that particular point in time.
Okay, not meant for you to hear. You are the defense attorney for an individual charged for this crime, right? For this RICO conspiracy. The minimum sentence is like 54 years, the way a state has charged this, right? So you're saying that you're not supposed to know. How dare you know the information we're trying to threaten your witness to give us that will affect your client's right to life and liberty going forward? How dare you, Mr. Attorney, try to defend your client? Oh my God, here we go.
The prosecutor on the case, Adrian Love, said there was nothing improper about what happened.
Oh, Miss Love, Miss Love, Miss Love.
Direct
No, Miss Love.
towards Mr. Williams, the right.
Okay, so I'm not going to make you have to listen with Miss Love said gobble, 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 dob, 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 dob. everything was fine. It was all good. And you should, like, everything the other attorney said, you should strike it from the record because he's wrong. The thing is, Miss Love is wrong. She has no case law to support herself. Mr. Steele had a case to support himself, as well as like all the judicial code of conduct. So we'll just go see what they say. We'll see what they say.
During these proceedings while court is in session to both counsel for both of his counsels.
Also, just as a pro tip, as a 3L law student, if you all are in law school or young attorneys or whatever, right? If you see someone up on the stand who's saying stuff like and this thing, we'll watch a little bit more of her. Just watch and see. You see the difference, Mr. Steele, like, Your Honor, we have these arguments. Here's our case law. Here's our point. And you see her like grasping for straws or breathing for air. Just watch the difference and just note it.
For Mr. Steele to be present in the courtroom, he can still be held in contempt. But for Mr. Williams to have representation of both Mr. Steele and Mr. Adams while court is in session, and that the court's remedy does not affect his ability to have his counsel of choice represent him during this.
So what she's saying right there, right, is that, okay, so young thug's attorney gets thrown in jail, right? He's thrown in jail. So the attorney he hired and chose is in jail. That doesn't affect his ability to have his attorney he wants represent him. That's fine. Even though his attorney's in jail. Huh. Sounds a bit sus.
Trial.
Now, later in the day, and I mean the evening after 7 p.m., attorney Ashley Merchant came to court to represent Brian.
All right. Here's what I was talking about earlier. Okay. We have Ashley Merchant, right? So Ashley Merchant, from the Trump case, a whole different thing, but she's part of like a rapid response team for the Council of Georgia Public Defenders and criminal lawyers, right? So if there is a lawyer who has a problem in court where he gets held in contempt, well, he gets into jail, there's like a bat signal that goes out, right? And Ashley Merchant and Mullet Man, I wish I knew his name, come in and they're like, boom, we got your back. We got your back. Here we go. So what's happening here is now Ashley Merchant is taking up Steele's case for the contempt charge the judge threw at him, I would argue, very, very unprofessionally. And Merchant just freaking came in the freaking bat plane, the Batmobile, and she's here in court, whispering in his ear. Looks a little weird, but that's fine. But to help him out. And so we're going to see what she does now. And she does great work. Like in this case, chef's kiss, Ashley Merchant. Great work. We'll see what you
Steele in this contempt matter.
Judge, just for the record,
Here we go.
So is the criminal contempt, is it criminal contempt that you held him in?
Yes, ma'am.
Okay, and you said you.
So here's the thing. The judge doesn't even know. The judge is wrong. The judge did not hold him in criminal contempt, which is a criminal violation of a judge's orders. There was no order he violated. The judge held him what is known in Georgia as direct contempt, meaning the judge directed you to do something. You said, no, I'm not going to do it. I'm not going to give you my source. And he had good reasons for that because he was, in fact, protecting his client's interest. He was, in fact, able under the client work product privilege in Georgia not to reveal that. So in this point in time, the judge saying it's criminal contempt is straight wrong. This is called direct contempt. Merchant doesn't get there, but just so we know what it is in Georgia, this is not criminal contempt. This has been held in direct contempt. We'll see what Merchant says.
You had a hearing earlier today.
And with criminal contempt, I told him what the contempt was, and that was
not criminal
he
contempt.
refused to tell, order the court. If counsel, as you know, if the court orders you to do something and you don't, that's criminal.
Again, no, he's wrong. If the court orders you to do something, you don't do it. That's called direct contempt, not criminal contempt. The judge has lost his noodles long ago, and it is
contempt. So I've asked him several times, please just tell me who it is that
again,
told you. I didn't ask or inquire about anything that was said. I just want to know who it was. Because he's got too much detail of this particular alleged conversation for the court to be concerned about it. So,
and Judge, since it is a criminal contempt, he is entitled to due process. He's entitled to a hearing, entitled to an actual show cause, entitled to the allegations actually written.
So she's right. So here's the whole thing, right? At this point in time, Ashley Merchant is right. The judge got it wrong and said it was a criminal contempt. Merchant knows this, I think. and says it's not a criminal contempt, it's a direct contempt. But since you say it's a criminal contempt, okay, we'll play your game. Since you chose to give him criminal contempt, he gets all these due process rights, counsel, a show cause hearing, all these things before you can clap him to irons and send him away. And so she understands the judge is wrong, but she understands that, okay, judge, even if you're right, you have to do X, Y, and Z before you can throw my client in jail, before you can throw Steele in jail. And so she's going to ham that up right here. I think she does a great job about this. So let's watch.
Entitled to a witness list. We're entitled to present our own witness list.
Yep.
And
Well, no,
notice of that.
criminal contempt is different. It is on the spot. So
No, that's direct contempt, Judge. You're all Glanville, you lovely, beautiful human, you.
he's gotten the due process he's going to get. That's on the
he's
spot.
got the due
I
process
told him. Plus, he's had all
Isn't that
day
lovely?
to tell me who it is
No more.
that
No moss
is
for
it.
you.
So a little different, Miss Merchant. I'm going to disagree with you, but
Well, and
Okay.
Judge, just for the record, it's that's direct. So
See,
what
there
you're
you go.
holding him
Okay,
is
right,
in
right.
direct.
Thank you, Miss Merchant. Exactly what I was saying. That's direct. When she says that's direct, she means that's direct contempt, not criminal contempt, not civil contempt. That's direct contempt. So just what I was saying before, that's you directly refusing what the judge asked you to do in court. That's direct contempt. And so the judge says it's criminal contempt. No. By all of my knowledge in the world, that's Merchant is right. The judge is wrong. Let's see how she takes it.
Criminal contempt.
yes.
The issue with the direct criminal contempt is whether or not to actually
Okay, so she says direct criminal contempt, which kind of confuses things. So there's criminal contempt, which is most of the time indirect, right? There's direct criminal contempt and there's civil contempt, right? So there are three contempts that are out there. And so when she says direct criminal, she means she's trying to differentiate them, but she doesn't do a good job with the words there. But she's great. No shade on her. She's amazing, but like just about that part.
hold a hearing now, whether or not it needs to be held immediately.
It
And the
does.
problem is, if you hold him in direct criminal contempt, as you're saying that you did, you are a witness to that proceeding.
Yep.
And so it has to be referred to another judge. Doesn't
Damn right.
require recusal. You actually
So here's the thing. Here's about this, right? Is that if he's holding him in direct criminal contempt, right? What's he in contempt for? He's in contempt for sharing the information in the secret squirrel freaking ex parte hearing, right? Well, in order to prove that he was improperly sharing information, to prove that in a court of law, what are you going to need? You're going to need a witness who was there at that hearing, right? The whole point of Mr. Steele is that there was nobody at that hearing except for the prosecutors and the judge, right? So guess who are witnesses to what happened in that hearing? The prosecutors and the judge. Because of that, the judge becomes a witness of fact to that hearing and what happened in there. And so you can't, I don't care how high you think of yourself, you cannot be the person who's charging someone with a crime who's also a witness to that crime. That's not how we roll here in America. And that's what she's going to get into next.
have to sua sponte send it to another judge because you're a witness to the proceeding.
Sua sponte means on the court's own order, being like, I'm like, oh shit, I can't do this. Send to another judge.
If you're anything like me, you are always
I am
cleaning.
nothing like you in lots of ways. Okay.
Summary criminal contempt pursuant to OCGA 15-1-3, subpart 3, for your failure to comply with my earlier order today. I'm going to order that you be taken into custody, incarcerated at the Fulton County Jail for no more than 20.
Now the judge backs down. The judge's like, I sent you to jail today, but it's not today. It's like only on the weekends, but like every weekend between now and August 17th. So you see the judge here, in my opinion, right, knows he fucked up and is trying to walk it back softly because he's got Attorney Mullet, badass, Attorney Merchant, other badass, putting his feet to the fire. He's like, well, I know I was gonna, like, I just had you arrested. You took your coat off, your tie off, and I had you put in handcuffs. But, only on the weekends. It's okay. And there are gonna be problems with that.
Days for this contempt. Those 20 days consisting of every weekend for the next 10 weekends.
So August 17th.
And you'll
Right.
be reporting to 901 Wright Street Northwest, Atlanta, Georgia,
Fulton
30318
County.
at 7
We're
p.m.
right.
on Fridays. You'll be released on 7 p.m. on Sundays. And it's to commence this Friday, June the 14th at 7 p.m.
Right.
and not to end until Sunday, August the 18th at 20.
You understand that like it changes stuff, right? Like he was supposed to go in jail every day for all day for 20 days. Now the judge is already backtracking and saying, well, no, only on the weekend. So you understand how the judge already knows he's wrong and is trying to unfuck himself little by little.
2024, 7 p.m., subject to further order of this court.
Now, after the judge said that Brian Steele was going to have to spend his weekends in jail, Steele had just one request.
Yeah, purge bond.
Here.
Okay, I don't know who you are, woman. I want to watch the court here.
Would assume you expect to hear.
I don't assume anything. Let me hear him
The
talk.
appeal is pending. If we're successful.
All right, so let me talk about that. Okay, so let's the appeal issue, right? Okay, so here's the thing that Steele asked for, right? Or merchant asked for on Steele's behalf is a certificate of appeal, right? So let me break that down. So when you're in a criminal proceeding, right, what happens is that the judge issues a ruling that you think is bullshit. You say, Your Honor, thank you very much for that ruling. I want a certificate of appeal, which the judge has to take into account. Here's everything that's happened. Here's what the issue is. And I'm going to hand you a certificate, like a little golden ticket that says you can take this to a higher court. That's like this single issue, right? I'll pause the issue of you being in contempt. You can go ask the bosses up above me and they can say, hey, you're right. Hey, you're wrong. And then I'll take that into account in my ruling, right? And so based upon that fact, right, the judge can then interpret how he's going to do his ruling thereon, right? So basically the certificate of appeal means that this single issue in trial, which is whether or not it is proper to hold Attorney Steele in criminal contempt, can be taken up to an appellate court and they can give the ruling back down and the rest of the court can keep going on. But the judge says no. The judge is like, no, I'm not giving you that. No, F you. I'm the boss. I'm the man. That's what we're doing. And so that's where we're at, right? It's like, you can't take the certificate up. I'm not giving you the property process you should have. I said I hate you, and you're going to go up on, you can't even take it up to appeal. And thank God Ashley Merchant comes in and preserves the record and says, that, okay, Ashley Merchant comes in and says, Judge, you ruled wrong on this. It wasn't criminal contempt. It was direct contempt, which is a whole different freaking kettle of fish from criminal contempt, right? And civil contempt, which the judge was kind of back and forth, which he was even talking about in the first place. The judge doesn't know much, right? But the whole point is that they request for a certificate of appeal to appeal the issue of contempt to the upper court. The judge says no. And it's not going to be in this stream, but in the stream I'll do in a minute, Merchant filed a motion that preserves this into the record and also preserves the right to appeal and request an immediate appeal to the Georgia Appellate Court. In addition to that immediate right to appeal to the Georgia Appellate Court, Merchant put into that motion a little catnip, if you will, for the Georgia Supreme Court. It says, hey, Georgia Supreme Court, guess what? If you want to look at this and Georgia Supreme Court, you think this is fucked up enough, you can come down and snag it up and take it. Like the Georgia Supreme Court has the right and has the ability to take a lower appeals court case up to its own jurisdiction if it wants to. And Ashley Merchant very wisely put in the motion a very important part that says we're appealing it to the appellate court, but also, hey, Georgia Supreme Court, we're down here, listen to us. And at that point in time, the Georgia Supreme Court has the right and the ability to snatch it up and issue its final ruling right away. So going forward, before maybe even next week, if the Georgia Supreme Court is on its ball enough, right, or if not by mid next week, the Georgia Supreme Court could say, hey, Judge Ural Granville, I don't know what drugs you're on, but it's a problem. Also, Georgia Appellate Court, don't worry about it. The Georgia Supreme Court is taking it up, and we're going to give you the ruling. And the ruling will be, Mr. Glanville, you've overstepped your bounds. You've conducted an illegal ex parte hearing without proper notice to defense counsel or to any of the defendants they're representing. You then covered your ass by holding him in contempt because he wouldn't tell you the source. Again, under 6.1 Georgia attorney-client privilege rules, it's attorney-client work product. Attorney-client work product means that not just what your client tells you, but what any individual who's related to your case tells you that's relevant to your client's defense, that is secret, that is sacrosanct. That is not to be taken away from you by a rogue judge. So again, to close up here, Attorney Steele, hats off, brother. As a law student who fits to be a criminal defense attorney, you are a great man. And if I can follow you, even into contempt, into trial, and into jail, I will do it, sir. So everybody, have a shot, take a drink for Attorney Steele here. It was a great job. And I will be following this up in a little bit with the motion. I'll read the motion coming up. So like and subscribe, blah, 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 grift, I don't care. I'm just doing this for the fun, not for the lulz. So everybody have a great one, and thank you all so much for watching. But this is the end of it. Is he did the best job he could by his client. The judge was pissed. The judge fucked up. The Georgia appellate court will be taking this up on an emergency motion, and there's also a hook in that emergency motion to allow the Georgia Supreme Court to supersede the appellate court's authority, right, and to go ahead and decide themselves. So I would, if I was a betting man, suspect some sort of ruling from the Georgia appellate court on the emergency basis next week, if not from the Georgia Supreme Court superseding the appellate court's authority because of that hook that was in there. This is egregious, this is outrageous, and this is not justice. And this judge needs to be gone off this case, if not off the bench. There you go. I'll talk to y'all soon. God bless y'all. Tip your bartenders, tip your waitresses. Have a great night. I'll be reading the motion in a little while here, so stand by. Take care, y'all.